she gets some water.
We'll call the meeting to order. Those of you in the back that are standing, if you would like, you can move across the hall into the room over there. There'll be audio over there of the meeting, so you can go over there and be seated. We welcome all of you to our meeting today, to our Resource and Conservation meeting of the House and the Senate Resource and Environment Committee. We have some people here to discuss with us the federal ownership of our land in the state of Idaho. These people are from the state of Utah that have had a lot of experience both in their negotiations and also with their planning. And I don't believe there's been any federal land turned over to the states yet, but there's been a lot of discussion about it. And because we have had discussion here in the Idaho legislature for the last several years about this, why we decided it would be good to just have an informational meeting today for our committee members and the public to come and listen to the work that they've done in Utah and where they're at on this and what the proposals are. There will be no questions from the audience today, and there will be no testimony from the audience today. This is just an informational meeting. We do not have any legislative bills to testify on or anything that we need to discuss. The only ones that will be asking questions from the presenters today will be members of the Senate Committee and the House Committee. So with that, we'll get started. Our first speaker today will be Mr. George Wentz, attorney at law in the state of Utah. Mr. Wentz, if you'd like to take the podium.
Mr. Chairman, thank you very much. I actually thought that since we had the two chairmen of the Commission for the Stewardship of Public Land from the state of Utah here today, that it might be beneficial for them to give you a brief overview of what's going on in Utah. And if it is okay with the chair, we would then move to discussing the legal issues.
That will be fine. If you just present them in the order that they would like to make their presentation. And when they come to the podium, if they would state their name and their position and who they represent, so that our secretaries could get that in the minutes properly.
So we have with us today, we have Representative Kevin Stratton, and we have David Hinkins, Senator David Hinkins, and they are the two chairs of the Commission for the Stewardship of Public Lands of the state of Utah. I'd like to bring to the podium Representative Kevin Stratton.
Thank you. It's wonderful to be in Idaho today. This is God's country, and it's beautiful to wake up with beautiful sky and see the sun come over the mountains. I, together with Senator Hinkins, we are the co-chairs of the Utah Commission for the Stewardship of Public Lands. The commission was established because in Utah we're very, very concerned about our public lands. We have tremendous resources there in terms of beauty and pristine environment that we desire to protect. We often say in Utah that we're a public land state, and we will remain a public land state. But there is a challenge going on similar to our federal counterparts' ability to manage their finances and balance a budget. We see that same type of challenge in their management of public lands. And now, I'm not here to convince anybody of the effectiveness or ineffectiveness of the federal counterparts' management of public lands, but I am here to share with you that in Utah that we feel that as a state we could do a much better job if we controlled our public lands in the state of Utah. With that in mind, our legislature established the Commission for the Stewardship of Public Lands, charged with the duties to study and make recommendations to our legislative bodies as a whole, the House of Representatives, the Senate. Also charged to work with our Attorney General and Governor, the executive branch, as well as our federal delegation as we deal with these very important and key issues. We believe in the rule of law in Utah, that there is inspiration and divine providence in our Constitution, and that Constitution has provided ways to address concerns. We believe in Utah, as I believe you do, in the protection of the right of life and liberty, the pursuit of happiness. And truly, at the core of those God-given rights is the responsibility and the stewardship to control property. Let me be clear. We're not talking about the sale of public lands to the private sector. We are talking about the preservation of what we value. We have 5 national parks in the state of Utah. We have pristine wilderness. We have much to protect. That is at the core of what we're talking about. Now that message gets misconstrued often. Now certainly there are those pieces of property, like was stated in the 1976 Federal Public Lands Policy Management, Federal Public Lands Management Act, FLPMA, that contemplated the sale of land. That has to be a part of the equation. But we're not talking about selling anything that our outdoorsmen and our visitors from across the world value and treasure. In Utah, we have an $8+ billion industry. If we were to sell our public lands in Utah, it would be like a very successful dairy herdsman selling his cows instead of milking them. You can milk your cows for the lifetime. You only sell them once. We're interested in the milk and doing the best we can with our public lands. With that in mind, the Commission held and received an economic analysis on the proposition, recognizing that we have the economy strength and the economic vitality that's so important that it makes sense economically to transfer the control of our public land in the state of Utah. We then commissioned what I would call a dream team, a legal dream team to study the issue. And Senator Hinkins and I were very blunt with this legislatively approved and commissioned specialized legal analysis that was to take place. We said, look, if there are warts on this, we want to know. If there's problems with the legal right to have the lands transferred and be controlled by the state, we want to know. Well, they went through the process, and you have before you one of the 2 lead attorneys here today, Mr. Wentz, that will present to you that legal analysis. With that, I think I'll turn the time to my good senator for comment, and we'll look forward to any questions you may have. Thank you.
Welcome, Senator Hinkins. We appreciate you being here.
Thank you very much, and all committee members and general public. I'm very grateful to be here and speak on behalf of our commission for this Public Lands Transfer of Utah. I serve as the chairman of the Public Utilities Interim Committee and for Energy, and we're really bound in Utah by the things that can happen. We have a power line that's coming from wind generation in Wyoming, and that's going to end up in California, that we have no on-ramps or off-ramps for power. It's not going to affect Utah one way or another. So this, because of FERT, it's going to come through Utah and so they've gone through, and there's about 4 or 5 different routes that they were going to take. And when they come through, because the BLM and stuff has been so hard for them to work with, they're starting to come in and condemn private property. So they're going through people's property with these big high-powered lines. It's a DC line, a direct current line, similar to the one from the Intermountain Power Agency from the coal-fired power plant in Delta, Utah to California. And so they already own 66%, or they hold in trust 66% of Utah's public lands. And because they can't even work within the federal government, which is basically saying that we have to allow them through, we have no say basically of what we can and can't on the power line goes through there. So we're restricted of how we can grow in Utah. We can't even run a fiber optic line across the state of Utah without running into federal bureaucracy to get these lines and stuff in. It's a daily fight. As our state next to us, Wyoming, there's been a moratorium now on coal extraction, and it's a 3-year moratorium on any more BLM leases on coal extraction. And so I think it was in 2014, their revenues off their coal alone, it was about I'm not sure if it was coal alone, but it was extraction industry, coal, oil, and gas. It was about $760 million. And this year it's going to be about $25 million because of it's being prohibited. And like Utah, unlike Utah, a lot of their schools are paid for off of extraction industries from the royalties and stuff off of Utah. We had to implement an income tax in Utah. So 100% of our income taxes, federal, or our corporate as well as personal income taxes is how we fund education in Utah. And because Utah is one of the lowest funded, probably the lowest funded education system. We have a large population of young children, but we also are the lowest funded because we don't have the tax base to do that. So we have to do it through income taxes. And you know, it's all started kind of, there's a payment in lieu of taxes that the federal government pays the taxes on the land that they own, which they are the largest landowner in Utah, which is 66% of our land. And in a little county called Kane County, there's about 10% of the ground, the land that's able to be taxed, and they pay about $8 million a year in taxes off the public, the private entities, the farms and stuff, and the businesses. And the federal government owns probably about 92 or 93% of Kane County. And they pay about $1 million in payment of lieu of taxes. So you can see that $8 million is being paid off of about 5% to 6% of the ground, where 90% of the ground is bringing in about $1 million. And so it's just it goes off of 1956 appraisals, a lot of the ground. And so we settled for these payment in lieu of taxes, which was back when. And it's just not kept up with inflation. So I represent southeastern Utah, 6 counties, Grand County and San Juan County, and which is part Navajo Nation, and of course it's tax exempt as well. And so we're not able to fund the little counties. There's not enough, where 95% of Grand County is owned by federal government, and the payment in lieu of taxes, they get about $1.5 million. Where if it was on a equitable tax, like I said, $8 million they get off of 5 or 6% of the land versus $1 million off 95%. So if that was changed around, where we wouldn't even be fighting about this as much, but we feel that we're not being treated equally as far as the tax, where if it was in the hands of private industries and peaceful. So anyway, we've got a lot of problems. Our grazing has been cut 90% over since 1949. Our AUMs, and that's not counting the 550,000 AUMs that have been suspended on top of that. We had a 3 million herd of sheep down in Utah. We're down to about 260,000 sheep, and it's just we see our rural Utah declining and not being able to. Everybody's moving to the city on the Wasatch Front. This caused pollution problems. We need to get more people out on the land and more jobs out there, but we're so bound because of the prohibitive of the BLM and the Forest Service. And so with that, we've got to turn the time over to our George and for the rest of it. Thanks.
Committee, before Mr. Wentz takes the podium, are there any questions for Representative Stratton or Senator Hinkins?
Chairman. I do have one question for you, whichever wishes to tackle this. I'm trying to reconcile two different messages that I got here. You open saying that the plan is in fact to leave these public lands public and leave it open to the public. But then I heard that the plan is to extract revenue by putting it in the hands of private industry. So I'm trying to understand, how are you going to derive revenue and tax the land by virtue of its use by private industry while still remaining it, leaving it as publicly accessible public land?
Okay, well, when they put up the leases if the state had control of it, we would hopefully be able to lease up some of the oil and gas extraction industries. And right now it's being prohibited. They've withdrawn a lot of it, and so the revenues on it is anywhere from 12.5% to 18% in royalties that generates in the counties, and also the timber industry, which we was able to have jobs created from that. And so the income taxes off the jobs that are created by the oil and gas and coal industries was basically helping pay for the rural Utah, because that's where all the mines and all the in the Uinta Basin, that's where all the resources are.
Got a follow-up?
Go ahead.
Well, isn't it fair for folks to be concerned that the public access and use to that land would be pretty dramatically changed and limited once it's turned over for oil and gas exploration or timber?
That is not fair to make that conclusion. We have a state park. We would invite you to come and visit Dead Horse Point, next to Arches National Park, and it's a beautiful park that's been used. I can tell the disposition. Those are in the audience today. I hope you have security. I hope we can make it out alive. But I would say this. We've been blessed recently over the last many years with a great amount of technology that allows a subsurface value to be extracted and to protect the surface estate. I love to hunt, to fish, to ski, to snowmobile, to hike. The surface estate can be protected and access maintained. And by the way, one of the challenges that we have in Utah is federal management of those public lands is shutting down our access and our recreation and our opportunities to use, and that's part of the problem. So that would be my response, Representative. Thank you.
Okay, Representative, or Senator Stinnett.
Thank you, Mr. Chairman. Good afternoon, gentlemen. And I wanted to speak to you because you are with the state of Utah. I was just trying to understand your passion for this topic. It's my understanding that the state has spent quite a bit of money pursuing this, $14 million and $500,000 to Mr. Wentz. I'm wondering how much more you think that you have in your coffers to be able to pursue this.
So to date, 2 years ago, we appropriated $2 million from the legislature to begin our process. We're pleased to announce that we felt that we would be able to get where we are, having spent that $2 million. We're actually less than 50% of that has been spent to get to where we are. So we're very, very pleased with the progress and the providence in the funds. It really depends upon the process. Here's I don't know the particulars about state of Idaho, but let me just give you one way of looking at this. We share a wonderful treasure of resources below the ground in Utah, Idaho, and this region. In fact, if we have proper numbers, and this is coming from our federal counterparts, there's over $150 trillion of value. If we, as the state of Idaho, state of Utah, could capture 1% of that value, be 1.5 trillion. And if you could put that in the bank, and this is not touching any of the surface and recreational opportunities above ground, 1% of that in bank, and if you could collect interest on that 1.5 trillion annually, 1% interest, that would bring to the state $15 billion. Now, that's more than our budget in the state of Utah. With that $15 billion, we could greatly strengthen our education spending and what we're providing for the rising generation. We can take care of the infrastructure needs. And so, in perspective, Senator, there's been a lot of chatter. Those are opposed to what we're proposing because not on the legal argument, not on the management that the state can do it better, but on this notion, this 14 million. We would anticipate being very provident with every penny of every dollar that's spent. The final lawsuit is going to be a choice made by our executive branch. They may or may not choose the current attorneys that are working for the commission. That will be a competitive bid. We feel that we need to be wise. We recognize that someone that doesn't have money to buy lunch, $5 is a lot of money. But there's a cost-benefit analysis, like planting a tree that will bring almost infinite opportunities in the future. Not only will that tree grow much fruit, but that tree will grow seeds for other trees to be planted. So that's how we look at it, Senator. Does that answer your question?
Well, Mr. Chairman.
Follow up?
Thank you. Providing that it's, we're going to need a change of state and federal constitutions, how long, and how much money are you prepared to fight that fight?
May I ask the good senator a question? My question to you would be, what is the price of liberty?
Okay, that'll be enough to answer. I have one question. When you're talking about the federal lands being that much of the percentage of the state, and we're talking about public access, is the state or the counties maintaining the road system into those federal lands now, or do the federal people do it? And would the state be able to provide more access to these grounds for recreation and things like that than the federal government is allowing?
I'll turn the time to Senator for that. Thank you.
Right now, the county roads are being maintained on the Forest Service and also on the BLM property on the deserts and stuff with the RS 2477 roads is basically being maintained by the county, although the federal agencies are supplying some of the revenue for that.
Is the federal government on those lands actually restraining access to those lands over the last few years?
Yes, there's been a lot of trail systems, especially on the ATV trails, that's been excluded from the management plans by the BLM and also by the Forest Service. So we are being restricted quite a bit on where recreation can, and a lot of it's to do with managing for sage grouse habitat as well as for other endangered species and stuff. So some of it may be justified, but a lot of it isn't. We don't know.
If the state took over management of those lands, do you predict that there would be better access to the federal lands for public funds or public recreation and things like that than there is now with federal rules?
You know, like Idaho, we have state institutional trust lands, and so 10% of the ground in Utah is owned by the school kids, basically through a trust fund, and we're being actually restricted to access to those lands that belongs to the trust lands are being restricted because of that, and that's one of the reasons that we're doing it. You know, the federal government, for every dollar they spend to manage the lands in Utah, they get back 76 cents of that. And in the state institutional trust lands, for every dollar that they spend, they're getting back $11 to $14 for every dollar that they spend in revenue from the trust lands. And so we feel that we've already got a track record of the way the state can manage the lands, and especially for the resources that's there. And so I think that not only access, but all around recreational as well as hunting, we've been prohibited from a lot of places, especially on grazing areas, of being able to maintain fences, stock ponds. There's been instances where a lot of the areas are primitive that you cannot get equipment into where water resources are. And so, yeah, I think that's probably the reason that we're coming to the conclusion that we are as a state.
Representative Andrews?
Thank you, Mr. Chairman. My question is either for Representative Stratton or Senator Hinkins, and thank you for coming up and being with us today. One of the main objections, and there are about 4 that I hear from the public, is that if there were a catastrophic fire and we had control of the lands, we could not afford to fight the fire. Now, our state-owned lands are cleaner and there's less chance for them to burn and have a catastrophic fire. But if there happened to be one, don't you feel that FEMA or Homeland Security would come in and aid like they do with a tornado, a flood, or a hurricane?
You know, I would still think that the federal government would be liable for the fires for a while until we were able to get our forests back into shape to where they should be because of all the beetle infestation that we have in our state and the lack of timber industry that we've had. But, you know, we send, in Utah, this is we send them about $660,000 or $660 million a year in revenues off the extraction industries off of federal properties, and they are obligated to give us 50% of that back, which we now receive 47%. So we get about half of that back, around $300 million. And so it costs them about $280 million to manage the ground. So they're actually, the money that we send them is actually able to manage that. So the $185 million that it costs as an average to fight fires in Utah is actually being out of the money that's been sent to them from the extraction industry. And so we would, if we were able to get the resources, not just the land, but also the minerals under it, we would be able to manage it ourselves. We've done a study, an extensive study with the Utah State, University of Utah and Weber State. We spent some money to have that study done to see if we could even afford to take over these lands. And we came to the conclusion that we could either lose around $100 million a year to gaining at $1.3 to $4 billion, depends on the price of the potash or whatever, the oil, gas, coal, whatever the revenue. The price of oil at the time was at about $80 a barrel. It's now, of course, as everyone knows, quite down 30, 35 or something. But so that would make an impact on it. But so I'm not sure where that numbers are at this time.
Mr. Chair, may I follow up? Thank you. Thank you for the question. Part of the challenge that we're seeing is recognizing that the system is broken. The people are good that work there. They're Utahns and Idahoans and those that work in these agencies. But it would be clear to me that in an emergency that there would be that desire to help. But I would say this, that the management of our lands and our forests and our public lands have billions and billions of dollars in deferred maintenance. And part of the process, remember that the last public forest management plan that was done back in the 80s, and it appears that there's a real desire to manage them so that you have these mega fires as part of the cycle. But the problem with that is, what does that do to our air and our water and the wildlife and what we're doing? And we believe that there would be significant reduction in the risk of wildfire as the lands are properly managed and taken care of.
Okay, let's go on then.
Mr. Chairman. Mr. Chairman. Functional blind spot.
There you go. Representative Rippleday.
Hey, Mr. Chairman, I have a question for either of you two folks from Utah about the idea that the county maintains most of the roads on public land. I just want to be clear that, yes, some of the roads are maintained by the county, but when we're talking about ATV trails and other trails, how much of that is actually managed by the county? And the reason I bring it up is because last year in Idaho, we dealt with a huge issue of our own budget shortfall for all of our transportation needs. And we kind of almost cut it in half. But if I remember right from being on that committee, Utah's budget shortfall for transportation is $7 billion. And so if you add all of these federal roads by taking over control of the public lands, how do you afford that?
I'm not sure about the $7 billion, our budget, that's not correct at all. But the ATV trails are pretty much maintained by the Parks and Recreation Department of Utah State Parks, as well as the snowmobile trails and stuff like that. So, but they are, it's funded partially. I mean, the federal government does help subsidize it, and they do give us money to do that. So, but a lot of it comes out of the extraction industry that we talked about, the $600 million that's sent to them. A lot of that comes back in that form. So, in fees. But our total budget for Utah is only $14 billion total. So the $7 billion is not transportation. About 50% of that is education, and about another 30% of that is health and human services. And so our transportation, we bond the $7 billion is way out of our league for us. So that must be another state. Thanks.
Okay, Mr. Williams.
Thank you, Chairman Raybould. So, first of all, I'd like to thank you for having me. I've seen some of the social media, and I don't know if I can get some water. Is there any water? But I've seen in the social media comments about this Louisiana lawyer coming up from down south to take all of Idaho's land. And I'd like to just thank the people of Idaho, because my family and I have lived here for 5 years now, and we've had a wonderful reception. My son graduated from high school in Idaho, played for his football team at the state championship in the Libby Dome. I'm also an adjunct professor at the College of Law at the University of Idaho in Moscow. And so we're proud Idahoans, even though my office is in Louisiana. And what I've found out with my client base is the older I get, the more liberty they give me to live where I would like to live. And so that is exactly what I'm doing. So the issue before us today is we have a situation, as we all know, where the majority of the land in the West is owned by the federal government, while the majority of the land in the East is not. So if we look at the history, we all know that it started on the East Coast. The whole nation started on the East Coast, and the development moved west. Well, I hit the wrong button, so we're not going to show you a very good video. Let me see if I can do it. So the development of the nation started in the east, moved to the west, and until it hit Denver, they disposed of the land, the federal government disposed of the land faithfully. On the west side of Denver, however, they failed to do so. Now, I wanted to show you the state parks, how they relate to the overall the national parks, how they relate. Those are the national parks there, which I don't think anybody wants to touch and we all love. And those are the total federal lands. Now, in the state of Utah alone, you could drop the entire state of New York just into the federally owned lands. There's one county where you could drop the entire state of Connecticut. So, when it comes to dominion over land, the western states, as you can see on this map, are treated entirely differently than the eastern states. There's 38 states that are treated differently from 12 states. Today we're going to talk about the equality of the states, the sovereignty of the states, how the states and federal government interact. And I know this is constitutional legal theory, and sometimes people's eyes glaze over, and I don't blame you. So as we review these constitutional concepts, I want us not to lose sight what's really at issue here. That's my grandson Ari. He's my oldest grandson. So what's at issue is the future of our kids. The Constitution was very carefully designed to protect the life, liberty, and property of real people like our kids and my grandson there. As we will see today, our founders wanted sovereign power diffused. They wanted it broken up difficult to consolidate. This is because the more power is concentrated, the easier it is to abuse that power. The easier it is to slip from democracy to tyranny. The founders had just fought a long, bloody war, and they had just thrown off the yoke of the King of England, and they were determined not to create a central government that could itself become tyrannical. If we abandon that carefully crafted design, we threaten our children's future, the quality of life, their individual liberty. So that is why the legal theories that we're going to talk about today really do matter in real life. Now, according to an unbroken line of cases, the Supreme Court has ruled from 1845 through as recently as 2013 that the states must all be equal in sovereign power. Here is how Chief Justice Roberts put it, writing for the majority in 2013 in a case called Shelby County versus Holder. Not only do states retain sovereignty under the Constitution, there is also a fundamental principle of equal sovereignty among the states. Over 100 years ago, this court explained that our nation was and is a union of states equal in power, dignity, and authority. Indeed, the constitutional equality of the states is essential to the harmonious operation of the scheme upon which the republic was organized. The fundamental principle of equal sovereignty remains highly pertinent in assessing subsequent disparate treatment of states. Now, what happened in Shelby, the Shelby County case, is there were certain states and counties in those states that if they wanted to change their voting rights laws, they had to go to Washington, D.C. and get pre-clearance from Eric Holder, who was at that time the Attorney General. Alabama complained. They said, no, New York doesn't have to do this. There's other states. Michigan doesn't have to do this. You are treating us differently. We cannot be truly sovereign because we can't determine how to make our own laws. They made that argument, and the Supreme Court, relying on this long line of cases back to 1845, said whenever there is disparate treatment with regard to states when it comes to their sovereign rights, we're going to apply a heightened level of scrutiny. And when they did so, they struck down the pre-clearance provisions of the Voting Rights Act. Not an unimportant law. Now, the equal sovereignty principle makes perfect sense when we consider that our nation is indeed a federation of states. The central government was created by independent sovereign states that had just won their independence from the king, and they were not about to go into a new organization where they were going to be less than equal. In the past, where this issue has been raised, the issue of the ownership of public lands, the government has always argued that a state's dominion over the land within its borders has absolutely nothing whatsoever to do with sovereignty. So let me show you what caused the original dispute over whether the states would be equal sovereigns. It was dominion over land. 6 states had claims to western lands, while 7 states did not. You can see the landlocked states, and you can see the states that had extensive western holdings by their colonial charters over to the Mississippi. This is back during the Revolutionary War. Conflicting land claims among the states threatened to turn the states against one another at a time when they had to unite to fight the British. To make matters worse, under its 1609 charter, Virginia claimed a massive swath of land all the way to the Pacific Ocean. Maryland refused to join a union where it would be swallowed up by Virginia, or where Virginia could use its vast western lands to create subservient vassal states whose votes it could use to control, to stack the deck in Congress. They didn't want to, they would control their votes. Maryland refused to join the Union unless the original states were equal sovereigns. Meanwhile, France was standing by to support the states, but not until they could get their act together and form a government. The states had to unite to get France on board to win the war, but the Western lands impasse was so important that it prevented it. Maryland insisted that the states with Western land claims give those claims up. But who could they give them to? Maryland's solution was simple. The new central government that the states were forming would need to hold the lands in trust until they could be formed into new, totally equal members of the Union. In 1780, Congress agreed, passing this resolution, that the unappropriated lands that may be ceded or relinquished to the United States by any particular state shall be disposed of for the common benefit of the United States and be settled and formed into distinct republican states and have the same rights of sovereignty, freedom, and independence as the other states. After holding out for 4 years, Maryland finally relented in March of 1781 after Virginia and other states with western land claims had agreed to accept Congress's resolution. Almost immediately after Maryland signed the Articles of Confederation, France sent 20,000 troops in its fleet, and the war was over in about 5 months. I don't know how many men died while Maryland was holding out for sovereign equality, but I do know that as a result, the equality of the states was written into the very fabric from which our nation was formed. So in addition to the rulings of the Supreme Court, history also dictates that the states must be equal in sovereign power, and the states saw that as having an awful lot to do with dominion over land. As a matter of history, the government's position is wrong, but its position is also wrong as a matter of constitutional law. In a federal system, the states create the central power. It only works if they can adequately represent their interests in how the central power works. If some states cannot exercise the same sovereign powers as other states, they are weaker and can be taken advantage of by the stronger states. It would be exactly the situation Maryland refused to put up with during the Revolutionary War. So is Idaho weaker than New York because Idaho doesn't have dominion over all its land? Well, actually it is. Let's talk about 2 rights the Supreme Court has recognized as fundamental sovereign state rights: taxes and self-governance. Taxes are the fuel of self-governance, but Idaho can't tax 61% of its land. So it gets a sort of welfare check from the federal government called payments in lieu of taxes, or PILT. Do you think there is any political pressure placed on Idaho in Congress so it can keep getting these welfare checks? Talking to our congressional representatives, I think that there is. I know that this pressure is placed on Utah. Just listen to what Senator Mike Lee of Utah had to say on the Senate floor in explaining his vote against the Farm Bill. This is Senator Mike Lee. Congress lords its power over Western communities to extort political concessions from them like some 2-bit protection racket. That's a nice fire department you got there, Congress says to Western communities. Nice school your kids have. Be a shame if anything should happen to it. These states and communities are looking for nothing more than certainty and equality under the law, yet Congress treats these not as rights to be protected, but vulnerabilities to be exploited. Close quote. This is not what the framers had in mind. Our federal system simply cannot work as designed, where some states are weak and their votes in Congress can be controlled by the strong states. The citizens of the weak states will never be able to be equal to the citizens of the strong states. And that's what we have going on all over the West right now. Second, the federal system is based on a concept called dual sovereignty. The states created the federal government and granted to it only certain limited, enumerated powers, Article 1, Section 8. The states, on the other hand, retained the general power to legislate upon the health, safety, and welfare of its citizens, what the Supreme Court calls the police power. Why? To prevent tyranny, to protect individual liberty. This is how the Supreme Court put it in the first Obamacare case in 2012. State sovereignty is not just an end in itself. Rather, federalism secures to citizens the liberties that derive from the diffusion of sovereign power. Because the police power is controlled by 50 different states instead of one national sovereign, the facets of governing that touch on citizens' daily lives are normally administered by smaller governments closer to the governed. The framers thus ensured that powers which, in the ordinary course of affairs, concern the lives, liberties, and properties of the people, were held by governments more local and more accountable than a distant federal bureaucracy. The independent power of the states also serves as a check on the power of the federal government by denying any one government complete jurisdiction over all concerns of public life. Federalism protects the liberty of the individual from arbitrary power. Supreme Court in 2012. So how does this design work when a state does not have dominion over the majority of the land within its borders? Well, it really doesn't. Unelected federal bureaucrats thousands of miles away exercise police power over far more of Idaho than Governor Otter and the elected representatives sitting in here today do. And the citizens of Idaho can't vote out an unelected bureaucrat in Washington, D.C. the way they could vote you out. That's the power they are supposed to have. They are supposed to be able to go and redress their grievances at the local level for local issues. But over 61% of the state, citizens of Idaho can't do that. We have a wonderful group behind us today of concerned citizens here expressing themselves. If I had been giving this speech in D.C., I doubt that many of them would have made the trip. That's the point. Idaho is also denied the same sovereign power to take lands for use in public improvements that New York has. Idaho can't take federal lands for public improvements. They can't condemn federal lands. And you've got federal lands in the patchwork throughout the entire state of Idaho. So try to create a highway, like the north to south highway that we have is very difficult. If I come down to Boise, I'm usually driving over to Montana. So it's also hard to put a broadband system together. So that's another key sovereign right that Idaho doesn't have that the eastern states do have. They can put a road. If I'm in New York, I can put a highway wherever I want to. I can put a canal if I'm this body. So these are important sovereign rights. But think about it. Highways, broadband, and other public improvements make commerce. Commerce attracts population. And how is federal political power doled out at the level of the central government among the states? How are we as Idaho represented in the national government? House seats and electoral college votes are allocated by the census, which is based on population. No population, no political power. No dominion over land, no ability to develop commerce. No commerce, no population. No population, no political power. It's a vicious cycle, and Idaho is forever denied the same opportunity New York has to gain political power at the federal level. We can just never get there. If you wanted to gerrymander the nation to prevent Idaho from ever gaining political power in Washington, D.C., you would take 61% of its land away. That map shows a nation that is gerrymandered. The West, by the denial of sovereign dominion over its land, will never have the same political power as the populated East. So the government is wrong. The fact is the constitutional system was designed upon the assumption that each state would have dominion over the land within its borders, and it just doesn't work when certain states are denied that right. Our federal system doesn't work unless all its members are equal. Therefore, when new people come in, when new states come in, they have to be equal too, right? The new guys have to get what the old guys got. That's the equal footing doctrine. It's very simple. So, did Idaho get the same sovereignty that the original 13 got? Well, if you look at it, Idaho really didn't. Not yet, anyway. Ownership of the unappropriated public lands historically always rests with the sovereign as an inherent incident of sovereignty. Doesn't matter what nation you look at, the unappropriated lands are owned by the crown, by the government, by the king, whatever it is. The King of England owned all the unappropriated public lands of the 13 colonies as an inherent incident of sovereignty. Upon independence, the original 13 states stepped into the shoes and they succeeded to ownership of the unappropriated public lands within their borders as an inherent incident of sovereignty. New states are admitted as equal sovereigns with the original 13 states. So if you follow that logic, Idaho should have received dominion over the unappropriated lands within its borders, just like the original 13 states did, because that's what the equal footing doctrine demands. However, Idaho has been denied ownership of the exact same category of lands the original states got as an inherent incident of sovereignty. So what am I missing here? Why is this? What I'm missing is a piece of history. You will recall that to resolve the Western Lands impasse, the states with Western land claims agreed to cede those lands to the central government to be held in trust until it could turn them in to new, fully equal states, right? They were to dispose of the land and to turn them into new, fully equal states. But the deal was that the federal government was only holding the land temporarily in trust and would dispose of it so that a newly admitted state could grow to have dominion over the land within its borders, just like the original 13 states all did. And everyone knew the federal government was going to dispose of the land because at that time there were only two sources of revenue, tariff and land sales. They didn't have any other form of revenue at the time that all these agreements were made. Here's how the Supreme Court put it in Pollard v. Hagan in 1845. Whenever the United States shall have fully executed these trusts, the municipal sovereignty of the new states will be complete throughout their respective borders, and they and the original states will be placed on an equal footing in all respects, whatever. And this is exactly what happened from 1785 until 1913. Anybody know what happened in 1913? Yes, sir. We passed the 16th Amendment and we had an income tax. We gave the federal government a new revenue source, and suddenly they lost all interest in liberating the Western lands. But not only did they lose interest in liberating the land, in 1976, Congress somehow discovered that instead of holding all that land in trust for the newly admitted states, it was really theirs and they were going to keep it forever. The admission compact they made with 12 Western states simply went out the window. The mechanism for allowing these 12 states to grow into equal sovereigns was abandoned, and Idaho never got its turn. So this is what we're left with. 12 Western states that contain 90% of the federal land in our country, about 1/3 of the nation. And now, instead of what the Supreme Court said had to happen in Pollard v. Hagan, this is what we have. Now the United States will never fully execute these trusts. The sovereignty of these 12 new states will never be complete throughout their respective borders. And they and the original states will never be upon an equal footing in all respects, whatever. We've talked about 3 different theories here today, but really they work together as a whole. We start with the premise that all states in the federal system must be equal in sovereign rights. Shelby County v. Holder, 2013. From this, we can derive that newly admitted states must also have equal sovereign rights. The admission compact made between the federal government and each newly admitted state was that was the mechanism that allowed that state to grow into equal sovereignty with the original states. Sadly, the federal government has breached that compact, violating both the equal sovereignty principle and the equal footing doctrine. And that is a result that the Constitution doesn't allow. Idaho deserves to be allowed to grow into an equal sovereign state with sovereignty over the land within its borders, just as the Supreme Court described and just as the Constitution demands. Thank you.
Okay, committee, is there any question for Mr. Wentz? Senator Stinnett.
Thank you, Mr. Chairman. Good afternoon, Mr. Woods.
Good afternoon.
With all due respect, I wouldn't want Idaho to look like our eastern states, but beyond that, within our Constitution,
That'll be enough of that, we'll have no applause during the meeting.
beyond that, as you probably know, many western states, Idaho and Utah included, signed a disclaimer clause that the people of the state of Idaho, in this case, do agree to declare that we forever disclaim all right and title to public lands lying within the boundaries thereof. And that, as a territory, agreed to this disclaimer as a condition of statehood, which is a little different than what happened in eastern states. Our own Attorney General went on to say that the Idaho Territory was created as an act of Congress on March 4th, 1863, and signed by in law by President Abraham Lincoln as an act of Congress. And during the Civil War, the Idaho Territory was created from lands that had previously been organized as both the Oregon Territory and the Washington Territory. In other words, the federal government held these lands a long time before Idaho ever became a state. It is quite difficult to take back lands that we as a state have never owned. And even Utah's Kevin Ivory from Utah advocates this idea, readily acknowledging that Idaho never owned these lands. So I guess my question is as we go forward and you're trying to change constitutionality, are you proposing to nullify the conditions of statehood as the agreements we've made in the western states as state become states?
You know, that's a good question. So let me talk, if you have time. Do we have time? To address the disclaimer clause issue for you. I actually thought someone might ask this question. So there is a theory that disclaimer provisions constitute a bar to transfer. There's 3 reasons why that is probably not correct. Not probably, it's just not correct. It's not correct constitutionally and it's not correct historically. I would also like to point out that my entire analysis, which has been done with Professor Ron Rotunda, who's an eminent constitutional scholar, Professor Rich Seaman of the University of Idaho, who served as the Assistant Solicitor General for 8 years, worked very closely with John Roberts, has argued before the Supreme Court 15 times. We're very lucky to have him in the state of Idaho. He's a tremendous legal mind. So this is not George Wentz. This is Ron Rotunda, George Wentz, Rich Seaman. I just happen to be the guy that got to stand here today. So there's 3 reasons. First, if you look at these provisions, what they really are is an en masse clear title provision. If you want to sell your house and I claim you own your house, you can't sell your house until that's cleared up. All right? From the beginning, what the United States was doing was holding land in trust and disposing of it. Actually, none of the states owned their land except the original 13 colonies, because all the states were created by land that was held by the federal government first and then disposed of to be created in the new equal sovereign states. That was the deal that was struck before the Constitution was even written to resolve the Western lands impasse and settle the war, bring the French in. That was the story I told about Maryland. So none of the states except the original 13 colonies ever owned their land. So if you want to use that as a standard, none of us could ever own our land. But in order to make that land be sellable, they had to put provisions in to allow, to make sure there's no disputes. The disclaimer clause is actually all the citizens in the state of Idaho saying, look, if we haven't claimed it already, we're not claiming it ever again. All right? So that it's the government's, so that the government can dispose of it. The second reason is they've never been a bar in the past. They've never been a bar to any other state that has the exact same provisions. The third is that if it's interpreted as a bar, they would be unenforceable. So let me explain. Why are the disclaimer clause en masse clear title provisions? You remember the ceded land, all that gray land was ceded, right? That was originally owned by the colonies that claimed it. It was all ceded to the government to be disposed of and turned into equal sovereign states. When they did that, they passed the Northwest Ordinance. All the land east of the Mississippi and north of the Ohio River was actually claimed by Virginia, and it was ceded by Virginia, and all the other states sort of went along with that. In order to be able to dispose of that land, which is what the Constitution now says and what the Northwest Ordinance of 1787 required, they had to be sure that nobody would claim they owned it. In this instance, it was all owned by the colonies, so they knew who owned it. The colonies owned it. The colonies had ceded it to the government, and now the government held it in trust to be turned into states. So what they required in the Northwest Ordinance was that the legislatures of those districts or new states shall never interfere with the primary disposal of the soil by the United States in Congress assembled, nor with any regulations Congress may find necessary for securing the title in such soil to the bona fide purchaser. All right? So we're going to sell it and we're going to give it to the bona fide purchaser, and in order to do that, we have to make sure the new legislature doesn't say they own it. Here's how the court in Gibson v. Chateau said it. No state legislation can interfere with this right, the right to dispose, or embarrass its exercise. And to prevent the possibility of any attempted interference with it, a provision is usually inserted into the compacts by which new states have been admitted into the Union that such interference with the primary disposal of the soil of the United States shall never be made, with the further clause that the legislature shall also not interfere with any regulation that Congress may find necessary for securing the title in such soil to bona fide purchasers. All right? Now, this is what we were using under the Northwest Ordinance, which was land that came from the colonies. We knew who owned it. See that purple land? That's Louisiana. So, what we have is we have, for the very first time, an acquisition with Louisiana Purchase where we're getting foreign land. It's not coming from a colony. We don't know who owns it. We don't know what kind of claims people might have. In fact, at the time of the Louisiana Purchase, there were both Spanish and French titles that had been given to the citizens of Louisiana, right? So what happened was the Congress set up a system where people who had titles given to them by the French and by the Spanish could come in and register them with the land office, the U.S. Land Office in Louisiana, and get those titles registered and recognized. That actually went on from 1805 until 1811, and Louisiana came in 1812. So if we look at all the states that are on the Northwest Ordinance, where they came from people who we knew who owned it, we have the shall never interfere with the primary disposal of the soil. The first time we get the alternative language is following the Louisiana Purchase, and it appears in the Louisiana Enabling Act, that the said convention shall provide by an ordinance irrevocable without the consent of the United States, that the people inhabiting the said territory do agree and declare that they forever disclaim all right or title to the waste or unappropriated lands lying within the said territory, and that the same shall be and shall remain the sole entire disposition of the United States. If we look at the Idaho Constitution, Article 21, Section 19, which was ratified by Congress, it has the same provision, except it inserts some clauses about Indian land, which you didn't really have in Louisiana, so it wasn't there. And it says, and the people of the state of Idaho do agree and declare that we forever disclaim all right and title to the unappropriated public lands lying within the boundaries thereof, and until the title thereto shall have been extinguished by the United States, the same shall be subject to the disposition of the United States. So what this provision is intended to do is create clear title in the U.S. government so that it can dispose of the land as it did in all the other states where this provision is included. So instead of it being a bar, this is actually to facilitate the disposal, the transfer of the land. If it was a bar, which it's not, it's clear. If you talk to a property lawyer and they look at this language, they go, yeah, that's clear title language. It quiets title so that the land can be disposed of. They've never been a bar to disposal of public lands in the past. So I put together the forever disclaimed states, okay? We have Louisiana, has no federal land, very little federal land. All the land was transferred. When Louisiana came in, it was 90% owned federal, maybe more. Now it's basically no federal land. Mississippi, same exact clause, same exact situation. Alabama, same clause. Nebraska, same clause. North Dakota, South Dakota, Oklahoma. So if it was a bar, why is it not a bar in those states? If we look at the never interfere with the primary disposal of the soil states, it's interesting. You have a couple of states, California and Oregon in the West, where they reached out and used the Northwest Ordinance language. I don't really understand that yet. I'll probably figure it out one day. But those states are in group with people who, other states that got got dominion over all their land, while California didn't. So, at least, what this is clear is that these provisions were made so that the disposal of the soil could take place. It hasn't operated as a bar in any other states, and it wasn't intended to be a bar. It was intended to facilitate disposal. So, if they were interpreted as a bar, would they be unenforceable? They would be unenforceable. Here's the deal. When states came in, they often had provisions in their enabling acts we had a situation in the southern states where there were various provisions in the Enabling Acts that said you always had to maintain the navigability of the rivers. But in this particular case, Withers v. Buckley up here, the state of Mississippi wanted to build a canal. And so the people that didn't want the canal, they said, well, they can't do that because it interferes with the forever navigable status of the Mississippi River, which was put into the Enabling Act for the state of Mississippi. And the court said this, clearly, Congress could exact of the new state the surrender of no attribute inherent in her character as a sovereign independent state or indispensable to her equality with her sister states, necessarily implied and guaranteed by the very nature of the federal compact. And they struck that provision down. They struck the provision of the Enabling Act down, okay? It was unconstitutional because it infringed upon the sovereignty of the state. Escanaba Lake v. Michigan Transport Company, the fact pattern is basically the same as Withers v. Buckley. The result is the same. Cardwell, Sands, those are all navigability provisions that were in Enabling Acts that were struck down because they infringed the equal sovereignty principle. Ward v. Racehorse, they actually struck down a treaty because the treaty, when Montana came in, said that the American natives would be able to regulate the fishing and hunting. And what happened was Montana objected to that. They took it to the Supreme Court, and the Supreme Court said, well, all the original states regulate their hunting, so obviously that provision must fall, and they struck it down. In Bolton v. Nebraska, there was a provision in the Enabling Act that required Nebraska to do a certain thing with regard to how they indicted criminals. And because none of the original states had that provision, they struck it down. In Coyle v. Smith, Oklahoma, the Enabling Act said that this capital of Oklahoma had to be in Guthrie. And actually put it in their constitution that it had to be in Guthrie, right? Well, somebody probably owned some land that they wanted to have the capital in Oklahoma City, so they brought a lawsuit and they said this infringes upon the sovereignty of the state because none of the original states, you didn't tell Annapolis that it had to be in Baltimore, in Maryland, you didn't tell any of those states where their capitals had to be. So it's unconstitutional infringement upon our sovereignty as the state of Oklahoma to tell us where our capital has to be. So even though it was in the Enabling Act, it was struck down.
Okay, I have just one question.
Yes, sir.
Has there been any Supreme Court cases recently on this particular issue? If there has been, what has been the outcome, and how long ago has that case been?
The closest situation is the Shelby County v. Holder, where the state struck down the Voting Rights Act. Now that was a congressional statute. That was not an Enabling Act, but actually an Enabling Act is legislation. So there's a history of when all the states were coming in, everybody was kind of getting it right. Well, we haven't had that many new states come in, and so there was a lull in this type of litigation. But these are the exact cases that the Supreme Court relied on in 2013 when it struck down the pre-clearance provisions of the Voting Rights Act. So there's no question as to the integrity of these cases.
1986, Utah Sovereign Lands. Utah Sovereign Lands.
Okay,
That was a difficult.
Secretary Bateman.
Yeah, thank you, Mr. Chairman, members of the committee. I've noticed that the last several years,
Just speak into your microphone, please.
during the last several years, there's been quite a bit of support for the theories that you presented here regarding state sovereignty and the overall proposal that some state lands some federal lands be transferred to the states, or at least managed by the states. But, among our representatives here elected, there's quite a strong feeling among many of us. But then I get almost most of the feedback that I'm getting from my constituents and people throughout the states is in opposition to that. Now that seems to me to be a strange situation here. The elected representatives of the people of the state of Idaho. We come from all walks of life. I'm a school teacher. I just took a few $1,000s to get elected. But your representatives, the representatives of the people, favor some, or inclined to agree with some of these proposals. But I'm getting all this negative information conscious of their own state citizenship. They don't trust their own people. They don't trust the people they elect. They'd be more inclined to trust people living along the Potomac River. They're more inclined to trust people living along the Potomac River, appointed bureaucrats and so forth, than their own elected representatives. And I'd just like to ask you, what do we need to do? We need to convey our message? Well, you know, typically I get the message, oh, we're going to sell all the land. I mean, people, when they phone me or get an email, oh, we don't want you to sell all the land. Well, that's not what you're saying. It looks to me like you've got to convey your message to the people in a clearer manner. If we're ever to convert them or to convince them to trust their own people, don't you trust your own people, the people you elect? Or you just want to trust the Washington bureaucrats? That's apparently who you want to trust.
I think I heard a question that, may I?
Yeah, what do we need to do?
If you would please translate that question for us and answer it.
Representative, thank you for what you've said. I think we all agree that we care about our public lands. And I believe that we all agree that we want what is best for the public lands. All of us in this room. We want them to be healthy. We want to have access. We want to protect the beauty things. And I agree with the good senator. The last thing I want is to look like an eastern state out here. I agree with you all on that issue. The question is, how do we get there? Because the current structure is failing. And we have to ask ourselves, are we going to be ruled by fear? Are we going to trust ourselves? We have the same issues in the Utah legislature. In a conversation with one of our senators that was very opposed to the whole notion, finally the question was asked, who do you trust more? Do you trust yourself and the citizens of our state, or do you trust unelected, faceless bureaucrats that have more to say what takes place in our state than our governor and the legislature and the people combined? I believe that teaching truth will prevail on the majority of the people. That's not to say you're not going to have the outspoken minority doing all they can to derail what you're trying to do. We want the same thing, I believe. A great question, for example, on fire control. We have the solution for fire control. I can take you to Montana and Utah where a fire is underway. And we have our state and county people there ready to put it out. And our federal counterparts tell us to stand down. And that fire grows from 100 acres to hundreds of thousands of acres. The policies are broken. May we be ruled by courage and principle and trust in one another. I am grateful for those that are here today. They have great passion. And if you turn that passion to doing the right thing for the right reason, we'll succeed. But if we turn that passion to fear, we're going to fail. That's my answer, Chair. Thank you.
Thank you, Representative Brown.
Mr. Chairman, I actually have two questions for Mr. Wentz. So it seems to me that even in the original 13 colonies, there is federal land, quite a bit of it, and even in those states, the states can't just decide to go drilling or seize that land or, even New York, their national symbol is the Statue of Liberty, but the New York government can't just go seize the Statue of Liberty at the national park. So aren't we in fact all on equal footing now in that no state currently has the ability to go seize or operate on federal land without going through the necessary procedures?
Well, no one is advocating that states seize land. and I want to make it really clear that I absolutely do not advocate that any citizen of any state goes seize any federal property. That is the wrong thing to do, okay? And we're not advocating that. That is not it at all. What we're talking about today is the question is, does the federal government have the constitutional power to forever, permanently own the majority of the land within a sovereign state, when that has such a disparate impact on those states as compared to 38 other states? It's a structural constitutional imperative that states have equal sovereignty for all the reasons that I just said. Now, the law that is really at issue here is the 1976 statute of FLIPMA, where the Congress reversed the policy that it maintained from 1785 until 1976. And in 1976, that's when Congress suddenly said, you know, we're going to treat this land like it's ours. We're going to permanently own it forever. And that's why we have the map that looks like it does, and that's the law that's at issue. Is that policy constitutional? So if the federal government does not have the constitutional power to own the land, there are many next steps that would have to be taken, and they would include, I believe, political issues that I'm not going to talk about. What I'm talking about is law. As a matter of constitutional law, the federal government does not have the power to forever maintain the majority of the land within a few sovereign states when it has not done so in other sovereign states.
Okay, Representative Senator Stidham. Oh, you have another question?
I just follow up. I guess I'm trying to understand, doesn't the federal government have the ability to indefinitely hold land in other states? Can't they hold Yellowstone and
Yeah. No, there's no question that the federal government can own land. In fact, that's why the property clause was put into the Constitution in 1787. What had happened was the Northwest Ordinance that we sort of touched on today was a system to allow, a very detailed system to admit new states, dispose of the land, form new states that could then become sovereign equal states and join the Union. And this was really imperative at the time that this be done, because otherwise Spain was trying to take that land, and we probably wouldn't have gotten it. So the Northwest Ordinance, there was some urgency about it at that time. So what was happening was they did that, and they looked at the Articles of Confederation, and they said, you know what? We don't have any provision in the Articles of Confederation to either own land or admit new states. So they didn't have those powers. So when they got to Article 4, which is the States Relations Clause of the Constitution, they put in all the stuff about new states. And they put that property clause in there. And the reason that they did it, according to James Madison, if you read the Federalist Papers, and of course he was the man who took the notes at the Constitutional Convention and proposed one of the original plans, he said that the reason for that property clause was to cure the defect in the Articles of Confederation that they were already doing. They were already doing it, but they didn't have the power to do it. So that's the reason for that clause. There's another clause through which we can own property as the federal government. It's called the Enclave Clause. It's in Article 1, Section 8, Clause 17. So there's no question. There is no question whatsoever that the federal government can own property. The federal government has done it for a long, long time. The question is, can the federal government treat 12 Western states in such a disparate manner when compared to the 38 other states? That's the question. It's one of fundamental equality. And, you know, this is a structural constitutional thing, but for the system to work the way it was designed to work, it is imperative that all the states have equal sovereign rights. Otherwise, the system that I've spoken about this whole time simply doesn't work. And we're seeing the results of that when you see Senator Mike Lee get onto the floor and say he's being strong-armed to vote a particular way or he won't get his PILT payments. That is because Utah is not a fully sovereign state. That's not the way it was supposed to work. The reason Maryland didn't join the Union is because it didn't want a bunch of states carved out of Virginia that would vote the way Virginia told them to vote. But now we have Western states being told to vote the way Eastern states want them to vote, or else they can't get their PILT payments and they can't educate their children. They can't have fire departments operating. They can't have police departments operating. That's not the way it was designed.
Did you have another follow-up for Representative Gray?
Brief follow-up. I guess I'm trying to understand, as long as they all have equal ability to access the public lands and equal ability to operate, under your definition, the only way that the states would be fully equal is if all states have the same amount of land, which surely can't be a constitutional requirement.
Thank you. It becomes an issue of succeeding the rights to the land. What we're talking about is you go east of Colorado, I don't think any of the states there are going to want to acquire any more of the land. And let me define what disposition means. Disposing the land does not mean that it's necessarily sold. It means the federal government disposes of the land. And that's in Utah, we're asking them to dispose of that land by transferring control to the state. The question I think before us is as applied, the 1976 FLIPMA Act, as applied, results in states in the West being second-class states, second-class citizens, discriminated against as applied. You can't build a road across your state in Idaho or Utah like you can in Montana or North Dakota without the permission of the federal government. That becomes the issue. Do we want to be second-class states, or do we want to take our place as equal sovereigns?
Okay, Senator Stinnett.
Thank you, Mr. Chairman, and whoever wants to answer this. In all fairness, I'm trying to listen to what you've just said. The federal government purchased these territories that became these western states, and all citizens in the U.S. pay taxes in order to run and pay for them. So they all have a piece of it, not just us. So in order for us to have that kind of sovereignty or say over it, it would be fair and correct that we would purchase them back in the event the federal government even sells to us. And in that event, there would be title attached to that. And I think that's the concern about access. So why should we have those just given back to us when the federal government purchased them and all citizens of the U.S. paid to run them?
May I?
Yeah.
Thank you. Thank you for the question. What you're dealing with is an issue of damages. You're advocating the notion, if they transfer, there is precedence within our history where the federal government has disposed of the park by transferring the states without compensation, number one. But we could get in to a discussion on you should pay for them if they come. But if we get into that discussion, we also need to have a discussion on what are the damages, the state of Idaho, what are the damages the state of Utah by not having access to these lands for the last 100+ years. And the damages, if we want to have that discussion, be in excess of the value of the land. Because generally, the value, if I'm renting a piece of, if I rent a piece of property, generally I'm going to recover the value of that land within 20 to 25 years. I've tried to answer your question. I'm not sure if have you understood what I've said? Thank you.
I personally would not be opposed to reimbursing the federal government for what they paid per acre for the ground. Representative Andrews?
Thank you, Mr. Chairman. I think it's obvious that there's a sense of distrust in the legislature and some days I don't trust us either, but I trust you. I trust the people. If we were to take control of the federal land within our borders, I think it would be my idea and proposal that we amend the Constitution so that the control of it would always rest with the people, always. It can never be sold off. The Department of the Land Board and the legislature would not have the authority or the power to sell it off and privatize it. And if you're concerned about Idaho being among the lowest in the nation in spending per student in schools, and our schools not being up to par, I'd just like to share some research that I did because I knew this was an issue that we're all concerned about. So I went to Legislative Services and I went to the Department of Lands, and I'd like to just share this, Mr. Chairman. As we know, forest and BLM constitute 60.9% of the land within our boundaries. State endowment land is 4.6, and we make $33.50 per acre gross off of our endowment lands. If we extrapolated that to the federal land within our borders, it would be $1,081,000,000. Now the net is $12.74. That would be $411 million. So that gives us the difference between $1,081,000,000 and $411 million to manage. Then the net would be $411 million to go to the schools or roads or however we'd like to use it. Now, wouldn't we like that? Thank you.
Any further questions? Okay, seeing no further questions, the committee, do you have any closing statements that you'd like to make?
I just want to thank you for your time and your patience and your questions. Very good questions. Very pleased to address them.
Okay, thank you so much for coming. Eric Sim Stratton, would you like to make a closing statement?
Thank you, Chair. I appreciate the opportunity to be here, and thank you for taking the time. This is a wonderful state. I have been here many, many times with my family and spent many weeks enjoying the public lands in this state. I hope that your commitment, if the lands are transferred, would be equal to Utah's commitment. You protect your public lands in Idaho, and we'll protect our public lands in Utah, and we'll have a better solution. Thank you, and I thank the audience as well for their passion and involvement.
Senator Higgins, do you have anything? Okay, thank you. All right, committee, unless there's any further discussion today on this subject or anything, we will adjourn the meeting. Thank you.